All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good afternoon. Good afternoon to the delegation of the Republic of South Africa, the Office of the Prosecutor, the public. I would ask, first of all, the court officer to call the case, please.
Thank you, Mr. President. The situation in Darfur, Sudan, in the case of the prosecutor versus Omar Hassan Ahmad Al-Bashir case, ICC reference case, ICC 02-05-01-09. For the record, we are in open session.
Thank you very much. I would now ask the representative of the Office of the Prosecutor to present their team.
Good afternoon, Your Honors. I'm Julian Nichols, and I'm here today with Rod Raston, Manoj Sachdeva, Melissa Sims, Stan Talansi, and our case manager, Dusan Illich. Thank you.
Thank you. Now I revert to the representatives of the Republic of South Africa to present their team. Thank you very much.
Good afternoon, Your Honours. I'm Sandhya De Wet, Chief State Law Advisor of the Republic of South Africa. I'm joined today, part of the legal team, Professor Claudie Direy-Claudie. He is the advisor to the Minister of International Relations and Cooperation, and Andre Stemmet, who is the legal counsellor in The Hague. We are also fortunate to be accompanied by our ambassador, His Excellency Ambassador Koloane, who is the ambassador in The Hague to the Kingdom of Netherlands. Thank you.
Thank you very much. Now I present the team of the chamber. The team is composed by Bruno Zehnder, Legal Officer, by Mr. Silvestro Stazione, Associate Legal Officer, by Mr. Simon Grabovec, Associate Legal Officer, by Dražan Đukić, Associate Legal Officer, by Theodora Jugerin, Associate Legal Officer, and by Marie Dang Van Sung, Intern. The chamber is composed by Judge Chang-ho Chung on my left, and on my right by Judge Marc Perrin de Brichambaut. I myself am Cuno Tarfusser, presiding judge. I think we can now start. The purpose of the present hearing is the delivery of the Chamber's decision under Article 87.7 of the Rome Statute following the hearing we had in this courtroom on 7 April 2017. I speak slowly for the translation into French to permit a sound translation into French. I shall now summarize the decision. This summary is not part of the written decision, which is the only authoritative account of the Chamber's decision and reasoning. The written decision will be made available to the participants, to the parties participants, and to the public at the conclusion of this hearing, and it is already filed. I start with a brief account of the procedural background and the relevant events. On March 31st, 2005, the Security Council of the United Nations, acting under Chapter 7 of the Charter of the United Nations, adopted Resolution 1593, whereby it referred the situation in Darfur, Sudan, since 1st July 2002 to the prosecutor of the court. The Security Council also decided that, and I quote, "The government of Sudan and all other parties to the conflict in Darfur shall cooperate fully with and provide any necessary assistance to the court and the prosecutor." Following investigations on the part of the prosecutor into the situation as referred by the Security Council, and upon application by the prosecutor, Pretrial Chamber 1 issued on 4th March 2009 and on 12 July 2010 2 warrants of arrest against Omar Al-Bashir for war crimes, crimes against humanity, and genocide allegedly committed in Darfur from March 2003 to at least 14th July 2008. The court, pursuant to Part 9 of the statute, transmitted to the state parties to the statute requests for the arrest of Omar Al-Bashir and his surrender to the court. South Africa was notified of the request on 5th March and 2009 and 16 August 2010, respectively. To date, the warrants of arrest against Omar Al-Bashir are yet to be executed, and pending his appearance before the court, proceedings against Omar Al-Bashir remain halted. In May 2015, the court learned from media reports that Omar Al-Bashir was intending to travel to South Africa for the purpose of attending a summit of the African Union due to take place in Johannesburg from Monday 7 June to Tuesday 15 June. On 28 May 2015, the Register of the Court, acting on the basis of these media reports, notified to the competent authorities of South Africa of a request for cooperation, requesting South Africa, 1, to arrest Omar Al-Bashir and surrender him to the court should he enter South African territory in accordance with Articles 86 and 89 of the statute, and in the event of any problem impeding or preventing the execution of the request for cooperation, 2, to consult with the court without delay in order to resolve the matter. On Thursday, 11 June 2015, the Embassy of South Africa in the Netherlands contacted the registry to request an urgent meeting between the registrar and the chief law advisor to the government of the Republic of South Africa and a delegation from the embassy with a view to entering into consultations pursuant to Article 97 of the statute. The following morning, on Friday, 12 June 2015, the pretrial chamber was informed of the request by South Africa to have a consultation meeting. It was then decided to schedule a meeting at the time proposed by South Africa, to be presided by the presiding judge of the chamber and to be attended by representatives of South Africa, the registry, and the office of the prosecutor. This meeting took place at 17 hours on Friday, 12 June 2015. During this meeting, the presiding judge pointed out, inter alia, that 1. all of the issues tabled by South Africa had already been decided by the court. And 2, the consultations had no suspensive effect on South Africa's outstanding obligations under the statute to cooperate with the court and proceed with the arrest and surrender of Omar Al-Bashir. The following day, Saturday, 13 June 2015, Omar Al-Bashir entered the territory of the Republic of South Africa. In the course of the day, the Chief State Law Advisor of the Republic of South Africa met separately with the representatives of the Registry of the Court and with representatives of the Office of the Prosecutor. In the evening of the same day, the Chamber received an urgent request from the prosecutor seeking that the presiding judge issue an order clarifying that, first, there was no ambiguity regarding South Africa's obligation immediately to arrest Omar Al-Bashir and surrender him to the court. 2, issues relating to domestic law did not nullify or change South Africa's obligation under the statute. And 3, South Africa's immediate obligation to arrest and surrender Omar Al-Bashir was not subject to any delay, stay, or suspensive effect. Later in the evening, on the same Saturday, 13 June 2015, the presiding judge rejected the prosecutor's request, observing that the position of the court maintaining that South Africa had an obligation to arrest and surrender Omar Al-Bashir to the court had already been made sufficiently clear and that no further reminder or clarification was necessary. Omar Al-Bashir left the territory of the Republic of South Africa in the morning of Monday, 15 June 2015. Despite the court's request for the arrest of Omar Al-Bashir and his surrender to the court, South Africa did not arrest and surrender him while he was on its territory between 13 and 15 June 2015. On 4 September 2015, the Chamber held that these events warranted the opening of proceedings pursuant to Article 87(7) of the statute, and in line with Regulation 109 of the regulations of the court, requested the competent authorities of South Africa to submit their views. A full chronology of the subsequent proceedings can be found in the written decision of the Chamber. Here, I only wish to recall that on 8 December 2016, the Chamber decided to convene a hearing for the purpose of receiving submissions in law or fact concerning, in particular, the following issues. First, whether South Africa failed to comply with its obligations under the statute by not arresting and surrendering Omar Al-Bashir to the court while he was on South African territory, despite having received a request from the court under Articles 87 and 89 of the statute for the arrest and surrender of Omar Al-Bashir. And if so, 2, whether circumstances are such that a formal finding of non-compliance by South Africa in this respect and referral of the matter to the Assembly of State Parties to the Rome Statute and or to the Security Council of the United Nations within the meaning of Article 87(7) of the statute are warranted. The Chamber invited to the hearing, in addition to the representatives of South Africa, also the prosecutor of the court and representatives of the United Nations. The United Nations subsequently responded, stating that it would not be sending a representative to attend the hearing and would not be making written submissions for the Chamber's consideration. As authorized by the Chamber, written submissions in advance of the hearing were filed on 17 March 2017 by the Office of the Prosecutor and by South Africa. These are respectively filings number 289 and 290 in the record of the case. In addition, the Chamber received written observations from the Kingdom of Belgium, filing 277, and from the Southern Africa Litigation Center, filing 288. On 7 April 2017, a public hearing took place before this Chamber. Representatives of South Africa and of the Office of the Prosecutor made submissions on the issues under consideration. The transcript of the hearings bears the number T2 in the record of the case. Article 87(7) of the statute provides as follows. Where a state party fails to comply with a request to cooperate by the court, contrary to the provisions of this statute, thereby preventing the court from exercising its functions and powers under this statute, the court may make a finding to that effect and refer the matter to the Assembly of State Parties, or, where the Security Council referred the matter to the court, to the Security Council. In exercising its competence under said provision, the Chamber has to answer two separate questions. First, whether South Africa failed to comply with the request for arrest and surrender of Omar Al-Bashir, contrary to the provisions of the statute. And two, whether a referral of the matter to the Assembly of State Parties or to the Security Council is warranted. I pass now to summarize the first of the two questions. With respect to the first question, the Chamber is called upon to analyze whether South Africa was entitled not to comply with the court's request for arrest or surrender on two independent grounds, namely, one, on account of Omar Al-Bashir's immunity, and or two, as a result of South Africa's interaction with the court in June 2015. Again, I shall address these two questions in turn, starting by the immunity. South Africa argued two distinct legal bases for Omar Al-Bashir's immunity at the time of his visit to South Africa in June 2015, namely, customary international law on account of his position as the sitting head of state of Sudan, on the one hand, and the host agreement concluded between South Africa and the African Union for the purpose of the African Union Summit on the other. The Chamber is not persuaded by South Africa's latter argument and considers that Article 7(1) of the host agreement on its terms does not apply to Omar Al-Bashir and thus could not have conferred upon him any immunity. Conversely, the Chamber notes that customary international law prevents the exercise of criminal jurisdiction by states against heads of state of other states. This immunity extends to any act of authority which would hinder the head of state in the performance of his or her duties. The Chamber is unable to identify a rule in customary international law that would exclude immunity for heads of state when their arrest is sought for international crimes by another state, even when the arrest is sought on behalf of an international court, including specifically this court. The Chamber must therefore determine whether there exists any derogation to the general regime of immunities under international law when the court seeks the arrest and surrender of a person enjoying immunity as head of state. This determination concerns primarily the interpretation of Article 27(2) of the statute and of its relationship with Article 98(1). Article 27(2) of the Rome Statute states, immunities or special procedural rules which may attach to the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. South Africa made the argument that this provision does not have any effect on the rights and obligations of states vis-à-vis the court, but concerns only the court's jurisdiction, ensuring that such jurisdiction is not excluded in cases of immunity or special procedural rules attaching to the official capacity of a person. The Chamber does not subscribe to this view and finds that Article 27(2) of the statute also excludes the immunity of heads of state from arrest. First, the Chamber considers that since immunity from arrest would bar the court from the exercise of its jurisdiction, the general exclusionary clause of Article 27(2) of the statute, in its plain meaning, also encompasses the immunity. Had the drafters of the statute intended exclusion only of a narrow category of immunities, they would have expressed it in plain language. The language used in that provision, however, conveys comprehensiveness and is not compatible with the proposition that the immunity from arrest of heads of state is excluded from it. Furthermore, reliance by state parties to the Rome Statute on immunities or special procedural rules to deny cooperation with the court would create, at least as concerns request for the arrest and surrender of individuals subject to a warrant of arrest, an insurmountable obstacle to the court's ability to exercise its jurisdiction. Such a situation would clearly be incompatible with the object and purpose of Article 27(2) of the statute. Indeed, the court's jurisdiction with respect to persons enjoying official capacity would be reduced to a purely theoretical concept if state parties could refuse cooperation with the court by invoking immunities based on official capacity. That said, the Chamber considers that the effect of Article 27.2 of the statute, as just described, concerns both vertically the relationship between a state party and the court, and horizontally the interstate relationship between state parties to the statute. On the one hand, a state party would have the duty to arrest and surrender to the court its own head of state if the court made a request for cooperation to that effect. On the other hand, a state party cannot refuse to arrest and surrender an individual on the grounds that the individual benefits from immunities based on official capacity belonging to another state party to the statute. Indeed, just as state parties cannot invoke their own immunities based on official capacity to refuse to cooperate with the court, they cannot invoke those same immunities when cooperation in the arrest and surrender of a person is provided by another state party. This is the effect inter partes of the statute, an international treaty. As there exists no immunity from arrest and surrender based on official capacity with respect to proceedings before the court, where any such immunity would otherwise belong to a state party to the Rome Statute, Article 98.1 of the statute is without object in the scope of application of Article 27.2 of the statute. No waiver is required, as there is no immunity to be waived. It is evident that this applies only to states that have consented to such a regime, which are in the first instance state parties to the statute, and states which accept the jurisdiction of the court under Article 12.3 of the statute. Nevertheless, the statute provides for a particular situation where obligations defined in the statute may become incumbent upon a state not as a result of its acceptance of the statute, but as a result of and under the Charter of the United Nations. It is to this sui generis regime that the Chamber now turns. The court's jurisdiction in the instant case was triggered by the Security Council Resolution 1593, whereby the Security Council, acting under Chapter 7 of the Charter of the United Nations, referred the situation in Darfur to the prosecutor of the International Criminal Court. For the reasons explained in detail in the decision, the Chamber finds, in line with previous decisions of other chambers of this court, that the effect of a Security Council resolution triggering the court's jurisdiction under Article 13b of the statute is that the legal framework of the statute applies in its entirety with respect to the situation referred. For the purpose of the present summary of the Chamber's reasoning, it suffices to observe that the ordinary meaning of the term refer, the context of a referral, which is the entirety of the court's legal regime, and its object and purpose all confirm that the effect of a referral is to enable the court to act in the referred situation, and to do so under the rules according to which it has been designed to act. Moreover, by deciding that Sudan shall cooperate fully with the court, the Security Council has also imposed on Sudan, acting under Chapter 7 of the Charter of the United Nations, an obligation vis-à-vis the court, which Sudan would not otherwise have, as it has not ratified the statute. The terms of such cooperation are set by the Rome Statute. The court is an institution whose competences are established by its statute and, indeed, which cannot receive cooperation but in accordance with its statute. The Chamber finds, by majority, that the necessary effect of the Security Council resolution triggering the court's jurisdiction in the situation in Darfur and imposing on Sudan the obligation to cooperate fully with the court is that, for the limited purpose of the situation in Darfur, Sudan has rights and duties analogous to those of state parties to the statute. It is acknowledged that this is an expansion of the applicability of an international treaty to a state which has not voluntarily accepted it as such. Nonetheless, the finding of the majority of the Chamber in this respect is in line with the Charter of the United Nations, which permits the Security Council to impose obligations on states. It may be emphasized that Sudan's rights and obligations are only those related to the situation in Darfur as referred by the Security Council, and strictly within the parameters of this situation. Accordingly, as a result of Security Council Resolution 1593, the interactions between Sudan and the court with respect to the court's exercise of jurisdiction in the situation in Darfur are regulated by the statute. One consequence of this is that Article 27(2) of the statute applies equally with respect to Sudan, rendering inapplicable any immunity on the ground of official capacity belonging to Sudan that would otherwise exist under international law. This means, in the first instance, that Sudan cannot claim vis-à-vis the court Omar Al-Bashir's immunity as head of state. Sudan has the obligation to arrest him and surrender him to the court. Second, in the view of the majority of the Chamber, the immunities of Omar Al-Bashir as head of state do not apply vis-à-vis state parties to the statute when they seek to execute a request for arrest and surrender issued by the court in the exercise of its jurisdiction in the situation in Darfur. Accordingly, Article 98(1) of the statute is not applicable to the arrest of Omar Al-Bashir and his surrender to the court. No immunity needs to be waived, and state parties can execute the court's request for arrest and surrender of Omar Al-Bashir without violating Sudan's rights under international law. Accordingly, South Africa was under the duty to arrest Omar Al-Bashir and surrender him to the court while he was on South African territory in June 2015. In any case, the Chamber finds it necessary to emphasize that Article 98 of the statute provides no rights to state parties to refuse compliance with the court's request for cooperation. Indeed, Article 98 of the statute addresses the court and is not a source of substantive rights or additional duties to state parties. While it does indicate that a tension may exist between the duty of a state party to cooperate with the court and the state's obligation to respect immunities under international law, it leaves to the court and not to the state party the responsibility to address the matter. The Chamber considers that in the case at hand, South Africa was not entitled to rely on its own understanding of Article 98 of the statute to decide unilaterally not to comply with the court's request for arrest of Omar Al-Bashir and his surrender to the court. Irrespective of all considerations made earlier as to the inapplicability under the statute of immunities on the ground of official capacity, the Chamber notes that the fact that an individual whose arrest and surrender is sought by the court enjoys diplomatic or state immunities is not as such an exception to the state party's duty to cooperate with the court. Even assuming, for the sake of argument, the existence of a conflict of obligations, this would not have relieved South Africa of its duties vis-à-vis the court or given it discretion to dispense with such duties. Article 98 of the statute simply does not have this effect. Accordingly, even in this scenario of the applicability of Article 98(1) to the situation at hand, South Africa, as a result of having chosen not to give effect to the court's request for cooperation, would still be found in non-compliance with its obligation to arrest and surrender Omar Al-Bashir to the court. I turn now to the second limb of the court's analysis of the question whether South Africa failed to comply with the request for arrest and surrender Omar Al-Bashir, contrary to the provisions of the statute. At the hearing of 7 April 2017, South Africa argued that fundamental errors occurred in the conduct of consultations under Article 97 of the statute, which were, it is recalled, aimed at discussing the application of Article 98(1) of the statute. Article 97 of the Rome Statute requires state parties to consult with the court without delay in order to resolve problems which may impede or prevent the execution of a request for cooperation by the court. This provision refers to examples of situations where consultations may be appropriate, but does not make explicit reference to situations falling under Article 98(1). This appears consistent with the fact that Article 98(1) of the statute already provides the solution for a possible conflict between the duty to comply with the request for arrest and surrender and the duty to respect certain immunities under international law. That said, the Chamber does not consider that Articles 97 and 98 of the statute must be interpreted as strictly as to say that the instrument of consultations cannot also be used for the problems under Article 98 of the statute. Indeed, communication between the requested state and the court in relation to Article 98, including provisions of information by the state under Article 195, under Rule 195 of the Rules of procedure and evidence may in practice take the same form as consultations. As a matter of fact, South Africa was given the opportunity to raise with the court the problems that it had identified under Article 98 of the statute with the execution of the court's request for arrest and surrender of Omar Al-Bashir. However, again as a matter of fact, it became clear during the consultations that the resolution of the matter brought by South Africa under Article 98.1 of the statute concerned the binary questions of whether or not South Africa had the duty vis-à-vis the court to arrest Omar Al-Bashir and surrender him to the court. No room was available for possible remedial measures to be addressed through consultations between the court and the requested state. In any case, the Chamber underscores that consultations, whether requested or ongoing between a state and the court, do not, as such, suspend or otherwise affect the validity of the court's request for cooperation. Even more, the availability of a channel for dialogue between the court and the state party, irrespective of the form that such dialogue may take, cannot be understood as resulting in a unilateral suspension of the execution of the request for cooperation. This is particularly important in cases such as the one at hand, where execution of the request for cooperation could succeed only in a very narrow window of time. Indeed, it is not the nature of legal obligations that they can simply be put aside on the ground of a disagreement with the determination of a competent court of law or perceived unfairness of the process and or the result. In these circumstances, the possible remedies can be of a judicial nature only, and the matter must ultimately be settled judicially by the court. The Chamber concludes that by not arresting Omar Al-Bashir while he was on its territory between 13 and 15 June 2015, South Africa failed to comply with the court's request for the arrest and surrender of Omar Al-Bashir, contrary to the provisions of the statute, thereby preventing the court from exercising its functions and powers under the statute in connection with the criminal proceedings instituted against Omar Al-Bashir. The Chamber makes this finding unanimously. However, part of the reasoning that I have just summarized is adopted by majority. Judge Perrin de Brichambaut appends an individual opinion, which he will summarize shortly. I turn now to the second question before the Chamber, which is whether it is appropriate to refer this matter to the Assembly of State Parties and or the Security Council. This is a separate question, and an automatic referral is not required as a matter of law in all cases of non-compliance. Rather, the Chamber has discretion to consider all factors that may be relevant in the circumstances on the case. In the present circumstances, the Chamber considers at first that the manner in which South Africa has approached its obligations to cooperate with the court is a significant consideration in the determination of whether a referral under Article 87.7 of the statute is warranted. In particular, the Chamber notes that South Africa is the first state party specifically to invoke Article 97 of the statute following receipt of a request for arrest and surrender. It triggered Article 97 of the statute in an attempt to resolve what is perceived to be conflicting obligations under international law. South Africa's subsequent conduct is also of relevance in this regard. South Africa presented extensive written and oral legal arguments on the matter and at hand, and indicated its intention to avail itself of the possible remedy of lodging an appeal in the event that the Chamber found that it had violated its obligation under the statute. Second, the Chamber considers that in the circumstances of the case, a referral of South Africa's non-compliance to the Assembly of State Parties and or the Security Council would not be an effective way to obtain cooperation. The Chamber notes that South Africa's domestic courts have found that the government of South Africa acted in breach of its obligation under its domestic legal framework, but by not arresting Omar Al-Bashir and surrendering to the court. In particular, the Supreme Court of Appeal of South Africa has concluded that the conduct of the government of South Africa was, and I quote, inconsistent with South Africans' obligations in terms of the Rome Statute and Section 10 of the implementation of the Rome Statute of the International Court Act 27 of 2002 and unlawful, end of quote. Importantly, this ruling has become final as the government of South Africa has withdrawn its previously lodged appeal against it. It therefore appears that the government of South Africa has accepted its obligations to cooperate with the court under its domestic legal framework. In addition, the present decision comprehensively and conclusively disposes of the matter as concerns South Africa's obligations under the statute. Therefore, should there have existed any doubt in this regard, it has now been unequivocally established, both domestically and by this court, that South Africa must arrest Omar Al-Bashir and surrender him to the court. Any possible ambiguity as to the law concerning South Africa's obligations has been removed. In these circumstances, a referral of South Africa's non-compliance with the court's request for arrest and surrender of Omar Al-Bashir would be of no consequence as a mechanism for the court to obtain cooperation. In addition, the Chamber observes that state parties have been referred to both the Assembly of State Parties and the United Nations Security Council in 6 instances in relation to failure to arrest and surrender Omar Al-Bashir. However, the past 24 meetings of the Security Council of the United Nations following the adoption of Resolution 1593, including meetings held on the occasion of a biannual reports made by the prosecutor of the International Criminal Court to the Security Council of the United Nations, have not resulted in measures against state parties that have failed to comply with their obligations to cooperate with the court, despite proposals from different states to develop a follow-up mechanism concerning the referral of states to the Security Council by the court. As previously expressed by another chamber of this court, the absence of any such follow-up is regrettable, and that it results in the inability of the court to exercise its functions and powers under the statute and renders any referral by the Security Council effectively futile. In view of the specific circumstances of this case, and bearing in mind its discretion under Article 87(7) of the statute, the Chamber considers that a referral to the Assembly of State Parties or the Security Council of the United Nations of South Africa's non-compliance with the court's request for arrest and surrender Omar Al-Bashir is not warranted. This concludes the summary of the Chamber's decision, and I will now pass the floor to Judge Marc Perrin de Brichambaut on my right for the summary of his individual opinion. You have the floor.
Je vous remercie, Monsieur le Président. Je m'exprimerai en français. Je voudrais dire que je souscris à la décision de la Chambre selon laquelle l'Afrique du Sud a manqué à l'obligation d'honorer la demande de coopération qui lui a été présentée par la Cour et en refusant d'arrêter Omar Al-Bashir et de le remettre à la Cour. Je souscris ainsi aussi à la décision selon laquelle il n'est toutefois pas justifié d'en référer à l'Assemblée des États parties ou au Conseil de sécurité de l'ONU. Je commencerai par présenter les raisons pour lesquelles je fais miennes les conclusions de la décision de la majorité selon laquelle Omar Al-Bashir ne jouit pas de l'immunité en matière d'arrestation et de remise. Cependant, étant donné que je ne partage pas l'analyse faite par la majorité s'agissant des fondements juridiques de cette absence d'immunité, il m'a paru nécessaire de présenter une opinion individuelle minoritaire. Je dois donc évoquer maintenant les questions de droit sous-jacentes à l'affaire, en particulier celles qui concernent, aux fins des poursuites devant cette Cour, l'immunité en droit international d'Omar Al-Bashir en matière d'arrestation et de remise. Ma position repose sur une interprétation de la Convention de 1948 pour la prévention et la répression du crime de génocide et des obligations qu'elle crée pour les États parties. Le Soudan et l'Afrique du Sud sont tous deux parties à la Convention sur le génocide depuis le 11 janvier 2004 et le 10 mars 1999, respectivement. Le 12 juillet 2010, la Chambre préliminaire numéro 1 a délivré un mandat d'arrêt contre Omar Al-Bashir au motif qu'il serait individuellement responsable en application de l'article 25.3a du statut du crime de génocide au sens des alinéas A, B et C de l'article 6 du statut. La Chambre préliminaire 1 a jugé qu'il y avait des motifs raisonnables de croire que des actes de génocide avaient été commis entre le mois d'avril 2003 et le 14 juillet 2008 dans l'ensemble de la région du Darfour. Dans ce contexte, la question de l'immunité d'Omar Al-Bashir doit être examinée à la lumière des obligations qui incombent au Soudan et à l'Afrique du Sud en tant que partie contractante à la Convention sur le génocide. Il importe de savoir quelles sont ces obligations et quelles sont leurs conséquences vis-à-vis d'obligations contraires que pourrait avoir l'Afrique du Sud à cet égard envers le Soudan et envers la Cour, comme cela est prévu par l'article 98 du statut, non seulement en vertu du droit coutumier, mais aussi en vertu du droit conventionnel. Il me semble que l'effet combiné d'une interprétation littérale et d'une interprétation contextuelle de l'article 4 de la Convention sur le génocide, conjointement avec une analyse de l'objet et du but du traité, amènent à la conclusion que lorsqu'ils doivent répondre d'allégations de génocide, les responsables d'un État ne sauraient jouir d'immunité personnelle. Au terme de l'article 6 de la Convention, ces immunités sont levées aux fins de poursuite, notamment devant, je cite, une Cour criminelle internationale. La Cour pénale internationale constitue de façon claire une telle Cour criminelle internationale. Étant donné que les immunités personnelles sont incompatibles avec les obligations des États parties à la Convention sur le génocide, le Soudan doit être considéré comme ayant renoncé aux immunités de ses représentants de l'État dès lors qu'il a adhéré à la Convention. Ainsi, je pense que la pleine participation du Soudan et de l'Afrique du Sud à la Convention sur le génocide a pour effet de lever l'immunité d'Omar Al-Bashir, faisant obligation aux parties contractantes à la dite Convention de l'arrêter lorsqu'il se trouve sur leur territoire. L'Afrique du Sud était tenue d'examiner si et comment la Convention pouvait s'appliquer à Omar Al-Bashir lorsque celui-ci se trouvait sur son territoire, étant donné qu'il a fait l'objet d'un mandat d'arrêt pour le crime génocide, et l'Afrique du Sud était tenue de mettre en œuvre son obligation. L'Afrique du Sud a elle-même invoqué l'article 98.1 du statut. Ce faisant, elle aurait dû chercher à savoir si la demande d'arrestation et de remise que lui adressait la Cour l'obligeait à agir conformément aux obligations qui lui incombent. Cependant, elle ne l'a pas fait. Les conditions visées à l'article 98.1 sont dès lors remplies en raison de l'antériorité de l'adhésion du Soudan à la Convention sur le génocide. Il en découle que l'Afrique n'aurait pas agi de façon incompatible avec les dispositions de l'article 98.1 que je cite, « obligation qui lui incombe en droit international en matière d'immunité d'une personne d'un État tiers ». Elle n'aurait donc pas agi de façon incompatible avec ses obligations si elle avait arrêté Omar Al-Bashir et si elle l'avait remis à la Cour. L'immunité de l'intéressé était levée de fait de l'accession du Soudan à la Convention sur le génocide. Au regard des rapports horizontaux entre le Soudan et l'Afrique du Sud, rien ne gênait l'exécution de la demande soumise par la Cour aux fins de l'arrestation et de la remise d'Omar Al-Bashir. En ne procédant pas à l'arrestation d'Omar Al-Bashir, l'Afrique du Sud a manqué à l'obligation que lui impose le statut. Il me paraît cependant nécessaire de compléter cette constatation par une lecture attentive des diverses positions juridiques en présence qui ont été évoquées par les parties elles-mêmes devant la Chambre. Car le fondement juridique de la conclusion de la Chambre me paraît revêtir une importance capitale. Je me sépare sur certains points des positions prises par la majorité de la Chambre. J'ai en effet été amené à analyser plus en détail de mon opinion individuelle minoritaire les importantes questions suivantes au nombre de 3. Première question. Le renvoi par le Conseil de sécurité a-t-il mis le Soudan dans une situation identique à celle d'un État partie, aboutissant ainsi à la levée de l'immunité d'Omar Al-Bashir par l'application de l'article 27 du statut de Rome? S'agissant de cette première question, l'examen des thèses présentées par le procureur et de celles présentées par l'Afrique du Sud révèle qu'elles sont chacune étayées par des éléments du statut et par la doctrine, et qu'elles présentent dans les deux cas des éléments de validité. Au vu des divergences qui existent entre ces thèses, les arguments en présence ne permettent pas de tirer de conclusions certaines sur la conclusion de savoir si le renvoi à la Cour de la situation au Darfour par le Conseil de sécurité a mis le Soudan dans une situation équivalente à celle d'un État partie. C'est pourquoi, en l'état actuel du droit, on ne saurait déterminer exclusivement, sur la base des effets juridiques de la résolution 1593 du Conseil de sécurité de l'ONU, si, en général, soit l'article 27.2 du statut, soit l'article 98.1 du statut s'applique entre la Cour, l'Afrique du Sud et le Soudan, en ce qui concerne la demande d'arrestation et de remise d'Omar Al-Bashir à la Cour. Deuxième question. La résolution 1593 du Conseil de sécurité a-t-elle levé implicitement l'immunité d'Omar Al-Bashir? S'agissant de la deuxième question, l'interprétation détaillée du contenu de la résolution 1593 du Conseil de sécurité, sur la base des éléments de droit énoncés par la Cour internationale de justice, aboutit à des résultats soit contradictoires, soit incertains. Le texte de la résolution elle-même, les interventions des États devant le Conseil de sécurité, ainsi que leur passivité, qui vient d'être rappelée à l'égard d'Omar Al-Bashir, ne permettent pas de parvenir à des conclusions certaines. Par conséquent, comme pour la question concernant le statut du Soudan à la suite de l'adoption de la résolution 1593 par le Conseil de sécurité, l'état actuel du droit ne permet pas de parvenir à une réponse certaine sur la question de savoir si cette résolution lèverait implicitement les immunités d'Omar Al-Bashir. Troisième question. L'implication d'une cour internationale affecte-t-elle l'application de la règle de droit international coutumier qui régit l'immunité personnelle des chefs d'État dans le cadre des rapports entre États? Pour ce qui est de la troisième question, les positions adoptées par les États, qu'ils soient ou non partis au statut de Rome, au cours des débats au Conseil de sécurité, dans les organisations régionales, à l'Assemblée des États partis, dans leur réponse aux demandes de coopération qui leur ont été présentées par le procureur de la Cour pénale internationale à 25 reprises devant le Conseil de sécurité, ainsi que dans leur pratique à l'égard d'Omar Al-Bashir, font apparaître une grande réticence de leur part à s'engager de façon claire sur sa situation et à agir de façon concrète. La Chambre, comme vient de le dire le juge président, avait demandé aux États et aux Nations unies de lui fournir des observations écrites sur la question de la non-coopération de l'Afrique du Sud. Elle n'a reçu qu'une seule réponse qui mérite d'être saluée. Ce silence presque complet donne la mesure du caractère très sensible de l'immunité des chefs d'État en exercice et des questions qui ont trait à l'immunité des gouvernants, ainsi que de la prudence qui domine à cet égard. Il est donc bien difficile de dire si la règle de droit international coutumier concernant les immunités des chefs d'État en exercice fonctionne ou non de la même manière si l'un des États impliqués agit conformément à ses obligations envers la Cour. Au vu des différentes interprétations possibles et légitimes des textes, de la coutume, de la doctrine, j'estime donc que l'état actuel du droit international ne permet pas de tirer des conclusions certaines sur l'une quelconque des trois questions que je viens d'évoquer. Je m'en tiens, contrairement à la majorité de la Chambre, à la conclusion selon laquelle la pleine participation du Soudan et de l'Afrique du Sud à la Convention sur le génocide a pour effet de lever l'immunité d'Omar Al-Bashir, faisant obligation aux parties contractantes à la dite convention, qui sont également États parties au statut, de l'arrêter lorsqu'il se trouve sur leur territoire et de le remettre à la Cour. L'Afrique du Sud était tenue de mettre en œuvre son obligation vis-à-vis de la Convention s'agissant d'Omar Al-Bashir lorsque celui-ci se trouvait sur son territoire, étant donné qu'il a fait l'objet d'un mandat d'arrêt pour le crime de génocide. Elle ne l'a pas fait. en ne procédant pas à l'arrestation d'Omar Al-Bashir, l'Afrique du Sud a manqué à l'obligation que lui impose le statut. Je vous remercie, Monsieur le Président.
Thank you very much. This concludes today's hearing, which had the purpose, as said at the beginning, to deliver the Chamber's decision under Article 87.7 of the statute. But before adjourning, I would like maybe to give guidance to the representatives of South Africa, which are probably not very familiar with the proceedings in this court. And as the representative of South Africa also requested, give guidance as far as the possibility to appeal this decision is concerned. In doing so, I would direct the representatives of South Africa to the provisions of Article 82(1)(d) of the statute and Rule 154 of the Rules of Procedure and Evidence. The decision, in any case, may only be appealed with the Chamber's authorization. And therefore, if South Africa wishes, or it will be determined after having read the whole decision, of course, to appeal the decision itself, it must file an application for leave to appeal within 5 days from the rendering of the decision. And in this application, it has to identify one or more issues arising from the decision which would meet the requirements of Article 82(1)(d) of the statute. I hope this is enough guidance, and therefore the hearing is concluded. I thank the representatives of the Republic of South Africa, the prosecutor, our assistants, colleagues, the public, and adjourn the hearing. The hearing is adjourned. Thank you.
All rise, veuillez vous lever.